I taught a class in a high school a couple of years ago, and it was the greatest question I've ever received from anybody I've ever talked to.
Oh, yeah?
Was a kid asked me, what's the newest thing in employment law? And I thought for a second, and I pulled out my phone. I said, this is it. And they said, why? So because everything that goes on right now is memorialized.
Yeah.
Whether you've done something good or bad. And, one of these kids started, well, that's illegal. I said, no, it's not. You're putting this in the public domain. And, if it comes down to, I've got two employees or two candidates, I'm trying to figure out who I want to hire.
And they're both the same.
Right.
Apples.
They both have almost identical experience, educational background. They're great. And then I start Googling them, and on one of them, all I see is pictures of them throwing up in trash cans. And the other one I see working with big brothers and big sisters and the rescue puppies. Who am I going to hire?
Welcome back to the Blackletter podcast. We set out to create an entertaining and exciting podcast about law and business, and I think we've done it. Blackletter, the name, comes from the Gothic typeset that was originally used in the Gutenberg press. Over time, Blackletter became the only font that English law books were printed in. Everything else was printed in regular type. It made it harder for kind of the common person to understand what the English law books said. Blackletter came to represent something that was law, that was set in stone, that was sort of old and a well-settled fundamental principle of law. We're here to demystify Blackletter law. We're here to demystify things that happen in business and law and where those two meet. And I hope you have fun listening. Hi, welcome back to the Blackletter podcast. I'm your host, Tom Dunlap. I'm here today with Phil Schwartz, not Dr. Phil Schwartz, but actual Phil Schwartz, attorney with Dunlap Bennett and Ludwig, and David Ludwig, also an attorney with Dunlap Bennett Ludwig. Phil is our principal guest today. Phil is an employment lawyer who represents employers only. He actually has said to me once, I once represented an employee once, and that was the last time he ever did that. So absolutely, there's a place for that kind of law, but today we're here to talk about the employer side of things, how to deal with terminations, what you need to know as an employer who employs people, whether it's 1099s or employees, all of these kinds of issues we'll talk about today with Phil, our expert. Welcome, Phil and David. Thank you for joining as our resident lawyer / Ed Sullivan today.
So happy to be here to chuckle at your jokes.
So such as they are, or Phil's jokes, and the Schwartz is with you.
Well, my jokes are all good.
So mine are horrible. So do you know that photons have mass? Like photons, light particles have mass. I didn't even know they were Catholic, but apparently they have mass. So,
first rule of employment law is we don't make religious jokes.
Okay. So now you can't fire me though, because I made it clear that I'm a photonist.
Okay. There you go.
So Phil, thanks for joining us today. I think the first thing that you and I were talking about before the show was the biggest challenge for every employer ever, even at law firms. How do you fire people? I think I said, how do you fire a developmentally disabled minority person with a certain religious preference, and it's nothing to do with any of those things. They just suck at their job, but you want to fire them. And every employer everywhere is like, oh my gosh, I can't fire them because X, Y, and Z. Not because they suck at their job, the reason they want to fire them. They can't fire them because they're worried about a status, a federally protected status, a state protected status, whatever it is. Who are these people? How do I fire them? How do I do that the right way?
I guess the first thing you'd say is you do it carefully.
Okay. Carefully.
Think about what you're doing and don't just act, but at the same token, don't be paralyzed. You've got to run a business, so you've got to actually take action. What I like to say with most people is let's look at the situation. Let's look at the individual. Let's try and figure out what, from the individual, the worker's shoes, what could they be claiming if they were upset with the action? So we look back there. Virginia, like DC, Maryland, and most states is what's called an employment at will jurisdiction, which means you can fire anybody at any time for any reason, with or without cause, with or without advance notice. But you can't fire them or because of a protected reason. So you can't fire somebody because of their age, their race, their religion, their national origin, their sexual orientation.
But you can fire them despite that. Correct. So even if they were, 55 or whatever the age is.
40 is the
40. Gosh,
40, yes.
I'm an old person now.
I was excited when I finally hit 40.
I can't be fired because I'm too old now. Is that right? No, it's not right.
Well, 40 and over is the protection under federal age discrimination law.
Okay, so I'm federally protected, but if I'm bad at my job, you should not be paralyzed. You should be able to fire me and say, well, it's not because you're old, but you wouldn't. Would you say that?
No.
Okay.
Well, the first thing I always say is never give a reason why you fire anybody.
Okay.
The reason Tom, we're letting you go today because we're going in a different direction. Things just aren't working out.
Different direction.
David has a box ready to pack up your personal belongings.
Thank you, David. Yeah.
That's the extent of the conversation.
So you say nice things when you fire people, always.
Just very little. It's an uncomfortable conversation.
Mm-hmm.
So the more you expand on the conversation by getting into reason,
the more you give them reasons.
Well, the more you're just giving them more to talk about. They're going to start arguing with the reason. I've made the decision to fire you. I don't really care if you say, no, that reason didn't exist. So I said, Tom, we're firing you because we think you stole petty cash.
But we shouldn't say that.
No, because you're going to now say, well, I didn't steal the petty cash.
I see.
I can prove it was David who stole the petty cash.
So I feel like employers really, if something like that happens, petty cash or bad performance or something, employers always want to tell their employees that. And that's the wrong thing to do. That's what you're saying, the absolute wrong thing to do
really
in any circumstance.
In almost any circumstance. Okay. The right thing to do is to document that reasoning, because that's the defense you have if the person turns around and says, well, they fired me because of my X, my race, my religion, whatever. So the answer then is no, you're an at-will employee. I don't need a reason to fire you. But if you want to say I fired you because of your race, I can turn around and say, well, I've got documented proof that you were stealing the petty cash.
So if you haven't done this documentation and the event happens, you don't have any backing, you don't have any history, is that a problem or can we still deal with that?
Creates more of a problem. As I like to tell clients, the documentation is really the defense.
Right.
You hope you never need the defense. It's kind of like going to a fight. You hope you don't have to swing, throw a punch. But if everyone's throwing a punch, you want to be able to pull out a gun. I don't want this to be an even fight.
Right.
And
bring a gun to the fist
to
fight.
A knife fight. Right. Yeah. The documentation is your defense. It's the bullets in the gun. And frequently we spend a lot of time creating that documentation and we never have to use it. And that's okay.
And it's better if you don't have to use it.
That's exactly it.
So another thing that I hear, so you said employment at will. And I hear that all the time, but we'll hear from the other side, employees. Well, it's a right to work state. I have a right to work. So tell me a little bit about what right to work is and what right to work we do or don't have if we're employees.
So
you're firing me, Phil. I have a right to work.
The right to work has absolutely nothing to do with whether or not you're going to stay employed here.
Right.
Right to work is very simple. It has to deal with a union security agreement. It really comes down to whether or not in Virginia, you can be forced to join a labor union to have a job. So for instance, we see, the cashiers at the giant grocery store. They are union members, but they do not have to be a union member in Virginia.
They have a right to work at Giant despite the fact that they're not a member of a union.
Correct.
That's what right to work means.
Correct. In Maryland, contrasting that, or in DC, you must join the union if you're going to work as a cashier in a Giant, because Giant has a collective bargaining agreement that covers all those workers. You must join it. It's the union security agreement. I hear this all the time, and it drives me crazy. It has absolutely nothing to do with this. I actually saw this in a blog article not too long ago where it referred to, Virginia is a right to work and at-will environment, so we can't fire. And it's like...
In the same breath.
In the same breath.
Was this a lawyer who wrote this?
I don't want to get into who.
Oh my gosh, I feel like you should email them. You heard it here first, folks. Right to work has nothing to do with employment and termination. Only unions. If you're not involved in a unionized sector of the world, it has nothing to do with you.
So is there any exception to the at-will employment doctrine where you can be fired for no reason?
Yeah, so what are the exceptions?
So exceptions would be a contract. Well, one exception actually is a union agreement, and most union agreements have the requirement that you can only fire somebody for cause.
Okay.
If, for instance, I have an employment agreement or even an offer letter that says, Tom, we want to employ you in this position for a period of 3 years, subject to termination for cause. We've now eliminated the at-will.
So you basically have just created a 3-year employment contract. Yep. A right to work. Not right to work in capitals, but right to work in lowercase.
You've created a guarantee of continued employment for a period of time that can only be terminated for cause. So now we're all of a sudden looking at a situation where we've got to deal with this now. So now frequently we're dealing with severance.
Right.
We're buying out the contract. It depends on whether
because they've got this 3-year agreement.
Exactly.
Yeah.
So
advice about making offers apropos or related to terminations. What would your advice be about how do you give an offer? What's the best way to give an offer?
The best way to give an offer is just a simple offer letter.
Okay.
I'm not a fan of employment agreements. I think in most situations, there's no requirement for one. If you're employing a physician and you've got HIPAA issues, you've got billing issues, third-party payer issues, absolutely, you need to have assignments of those rights in an agreement to the employer to bill people. But when you're hiring, for instance, just hiring a legal secretary or an associate at a law firm, an offer letter is all you need. So and the offer letter should just simply say, "Congratulations, we'd like to offer you a position of blank with this law firm. Your salary will be X or your hourly rate will be Y. You're required to be a member of the Virginia Bar, your whatever. These are your benefits. And by the way, all employment with this law firm is at will. This means that either you or the employer can terminate this relationship at any time without cause and without advance notice."
So you do that in every case. Now, a little bit of devil's advocate here. So say it's the position of an associate at a law firm.
Mm-hmm.
Or a software developer, or anybody who creates intellectual property. My common wisdom might be that you might want an assignment of the intellectual property in some kind of agreement that they have to countersign. But that would be essentially tantamount to an employment agreement or a separate agreement. What would you suggest?
So what I do in my employment agreement is, my offer letter rather, it says, that we're offering this position, it's at will, and it is subject to the policies and procedures of the employer.
Gotcha.
So now subject to the employment manual. And I usually say currently issued and as may be supplemented or modified in the future. And in certain circumstances, I'll also say, and employment is also contingent upon your execution of what I call an agreement on conditions of employment that addresses ownership of intellectual property, confidentiality, non-solicitation of customers. But I also still state in that agreement, you're still an at-will employee.
Yes, absolutely. Okay, that makes sense.
So I put that
reiterate at-will in everything.
So I put it in at least 3 places. It goes in your offer letter.
Okay.
It goes in if you have an application for employment, says if employed, you're an at-will employee.
Oh, interesting. Okay.
Again, the same thing. And then I put it in the policy manual.
So just to summarize, offer letter or application, offer letter, and policy manual. At-will, at-will, at-will.
Right.
So,
and then if we go into a non-compete type agreement, we go again in there, at-will.
Okay. So another question, so taking a species of this where we might want to contract, say we're employing somebody as a contractor, as a 1099 independent contractor. I know a lot of businesses are confused about this. A lot of businesses, in fact, I even know of a law firm, employ their employees full-time as 1099s. Can you do this?
Well,
they can have no other job. They work for only this company. Their name is in the company, but they're independent contractors.
No. So
companies do this though. So A, why can't we do it? And B, what are the consequences?
Well, so the first question is, somebody else does it. Well, my answer there is they just haven't been caught yet. Okay. So.
And caught by who?
They could be different agencies. So we've got the federal and state tax people. You've got the state workers' comp people are interested. The state unemployment commissioner in Virginia, the Virginia Employment Commission are all interested.
Okay.
It's all for, 3 of them, it's a tax grab. The 4th one, it's, people who are 1099s aren't covered by workers' comp.
So there's 4 state or federal agencies that are looking.
And there's a 5th and a 6th.
Oh.
There is the U.S. Department of Labor and the State Department of Labor, because 1099 contractors are not subject to the overtime laws.
Oh, interesting. Okay. So they're all looking at you for avoiding overtime laws, avoiding taxes, and avoiding reporting requirements, wage and hour, workers' comp.
Workers' comp. Somebody gets hurt. So, frequently
1099s aren't covered by comp.
No. So the quickest way we see those kinds of claims deals with either an unemployment claim or a workers' comp claim.
Interesting.
And
that's when the employer gets dinged badly.
Worse usually with the unemployment people than the comp people.
Okay.
Because the unemployment folks will come and audit your entire payroll, both employee and 1099 contractor. And you refer to something as 1099 employees or employee 1099s. We like to say engage them. We try and distinguish between employees.
Don't employ them, engage
them. We engage them.
You
right.
contract.
They're not employees, they're workers. Right. It's subtle. But, if you're making this argument, you want everything you have and to back you up.
So what kind of consequences? Say they come in and audit and it turns out 4 of your 10 employees are 1099s and they're full-time, essentially, employees.
So we're going to have the first thing we're going to see is an audit from the Virginia Employment Commission, probably.
Okay.
They'll go back 3 years and they'll go and hit you for penalties and interest going back 3 years for all your people. If you only have 4, it's not so bad. When you have 100
right,
and penalties and interest, this thing.
Have you seen this happen before?
I have.
Okay. So people do get caught.
Oh, absolutely. I actually, 15 years ago, I had an independent contractor case all ready to go to the Virginia Supreme Court.
Wow.
And the week before, the state kind of caved on a kind of mutual agreement that we would change our practices going forward, but they would not ding us or fine us going backwards. The reason for that was it was a pretty esoteric area, but the state was enforcing people and they were pushing people. I just happened to have a client who was prepared to fight this.
Wow.
The state was unwilling to take the chance of an adverse ruling against them because then they couldn't go and continue.
But that's not a good way to employ people. It's not safe to bet that you're going to end up spending tens of thousands with Phil Schwartz, hundreds of thousands, because you're an amazing lawyer, on true litigation. So summary of that issue is you have to employ your employees. You engage your 1099s. So what's the difference between a 1099 employee? How do you distinguish those two as a company?
So the first thing I do to clients, I say, well, tell me what this person does. What does he do for you? And how do you control him? So there's 2 different tests, or 3 different. There's a 20-point IRS revenue ruling that came out, I think, in 1986. That's a balancing act. You look at these 20 things, and it really kind of comes down to scope of control.
Okay.
That's the oldest test there is, and the IRS still looks at that. Now some of the states are using what's called an ABC test.
Okay, what's that?
And the B factor in that is basically it's 3 things, and the B factor is the important one. Could this company be in business without these people? So, for instance, if you're a law firm, okay, and you want to, and under the B factor, could a law firm be in business without lawyers who are now 1099? The answer is no.
Yeah. So
could they be?
All your lawyers are 1099s.
Absolutely.
What if the owning partner is not, and he has 2 partners that are, an associate that
doesn't matter.
So they couldn't be in business.
No, that's an integral function. The lawyer is an integral function.
Yeah.
Could you have a secretary? No, I need secretaries. But now, could I have a bookkeeper who maybe comes in 1 day a week?
Or a partial paralegal.
Right.
2 day a week.
Well, paralegal, no, because they're taking direct guidance from a lawyer.
I see. Okay.
But a bookkeeper who's coming in and say, here's the stack of bills, pay them. Yeah. Here's a stack of checks, record them.
What about an IT person?
Same thing.
But you're doing like off-site coding at a client site and you're billing them out as a 1099 and the client's paying 110 and you're billing the client at 150 an hour and you're taking the difference and putting 10 employees at that client site to code Cisco or whatever, some kind of software.
So are they employees? So this is kind of like a staff augmentation situation.
Yeah.
Now, are they employees of anybody or are they, so client A engages you, B, to bring in 3 programmers.
Right, correct.
Are the 3 programmers, are they employees of yours or are they contractors of yours?
Well, I'd like to make them contractors of mine, so you don't have to give them health care.
Yeah, but that's your business, though. That comes back to this. How am I, I'm in business providing these employees.
If I do nothing else, then it's a problem. But if I have a main business and I just do a small project, then maybe I could do it?
It's harder.
Okay.
So
it's case by case.
It's case really by case.
Fact-intensive inquiry.
People say, well, how come, so I need a temporary receptionist.
Right.
Well, that receptionist is a 1099. I call up, somebody temps, temps are us and they send me over, a receptionist. But that receptionist is an employee of Temps R Us.
Correct.
And Temps R Us is in the
doing
business.
the withholding.
And Temps R Us is in the business of providing temporary
What if
staff.
I hire that temporary receptionist off of Craigslist and they're an employee of no one and I just need them for 3 months because somebody's on a maternity
She's an employee.
Even for those 3 months?
Absolutely.
Wow. So you can't hire your own temp because they're not an employee of anyone.
Nope.
I did not know that. And I'm a lawyer, so that's probably not. I don't do that law, so that's good. That's why I have people like you who do that law.
One of the biggest case on 1099 contracts is the Microsoft case.
Okay.
And it went to the Supreme Court. And, it all had to do with the fact that Microsoft had these people that were working for them for years and years and years.
Wow.
And that this is the only job they ever had. And, I might be the employee and David's a contractor. And the only difference is I think the color of the badge I have. Oh, And David can't participate in any of the benefit programs.
Healthcare, 401k,
Stock purchase plan.
stock purchase plan. Oh, I could see that.
Remember that one?
Microsoft has been
vaguely.
killing it
Mm-hmm.
in the world of stock, especially in the last couple of years.
Right.
One of the, you do this, they'll invalidate all these tax advantageous plans
Yeah.
if they feel that's where the IRS can come in and really hammer.
Wow.
Because, that plan says you have to provide all employees with the right to participate. You've misclassified a large group of people as not being eligible to participate.
So what about employee handbooks? Do we need them or do we not need them?
We need them.
Everybody needs them? Like, what's the threshold, and where do you get an employee handbook?
So, a lot of places you can get them. I mean, if you're just looking for something off the shelf,
Mm-hmm.
if you're using Paychex or ADP, they'll give you one.
Okay.
The problem is they don't do a lot of great work customizing them.
Right.
I think one of the other problems with the ADP, or the Paychex handbook, it's incredibly thorough. It's also 70 pages long.
Right. So it's not practically useful.
Exactly. I mean, when I issue or put together a handbook, I actually want the employees to read it.
Yeah.
So I'll take the policy out on how to requisition a new desk. We'll deal with that on a case-by-case basis.
Right. Instead of having it in a manual.
Yeah. So, there's a couple of benefits of the manual. The first is, from a discrimination standpoint, it allows everybody to be treated the same way.
Right.
I walk into your office, you're the owner, I say, how much vacation I get? And you look up and say, 3 weeks. Next guy walks in, happens to be a woman. How much vacation do I get? 2 weeks. Well, we just created a problem.
And then David comes in and he gets a day. He's like, what?
Yeah, but look at David. He's under 40. He's a white male. He's got no protection.
Yeah, that's true. We get away with discriminating.
Exactly.
But he is a flaming Democrat, so I feel like we could probably discriminate.
In Virginia,
it's not protected.
In DC, it
Not
is.
protected.
Yeah.
In DC, political affiliation is. Yeah.
Is it protected? Oh, just in Washington,
Just in
D.C.
Washington, D.C.
But in Virginia, it's not.
Virginia, it's not. You get away with anything in Virginia.
Yeah, you can.
But I think there's like 5 or 6 other states that protect political affiliation.
But
And
in
I'm
Virginia, you could fire somebody for being a Democrat.
Yes.
But in D.C., you could not.
You cannot.
Wow. So that means incorporate in Virginia. That's the advice.
Well,
of the day.
it really depends where the person works.
Okay.
So you could be a Virginia corporation, but if you've got a DC office,
Yeah.
DC law applies.
Right. That's true. We've seen that with foreign embassies, I think,
Mm-hmm.
who wanted their own country's law to apply to their embassy, but it's D.C. law,
They're employing
which
people.
is a
in-
challenging law. So what?
Jurisdictions like to protect their residents and their employees.
Yeah. And they like to own and protect their own people. Thank you to our sponsor today, Dunlap Bennett and Ludwig. Dunlap Bennett and Ludwig solves complex business problems with smart solutions, acting as advocates and advisors to their clients with diverse professional backgrounds, from MBAs to PhDs to bankers to military officers. Real-world experience for real-world problems. Dunlap Bennett and Ludwig, doing better law. To find out more, visit www.dbllawyers.com. What are the top 3? Well, David, so if you were as an employer, what questions do you have for Phil that I haven't thought of today? What are the burning questions that we have? Like a pro here, I've learned 5 new things, and I've been involved in running companies for 20 years, and I'm a lawyer, I'm sort of shocked.
Well, I think the thing that's on everybody's mind right now is like the whole Me Too movement, right? What should an employer do if you hear about there being a complaint of sexual harassment or some inappropriate kind of workplace conduct? What should I just put my head in?
Or do you put it on Twitter, blog about it?
Exactly.
Probably.
That's probably the worst thing to do, is put your head in the sand and blog about it. Probably the second worst thing to do would be for the employer just to go start looking into it him or herself.
Okay.
It's really, I am one of these guys, lawyers, who likes to try and push people to do some of their own stuff.
Mm-hmm.
I don't want to, just create billing machine after machine, but investigating a sexual harassment type claim
Shouldn't be done by the employer.
It's really where
So who does the employer get to investigate it?
Law firms.
Law firms. Okay.
Yeah.
And how do you investigate a sexual harassment?
I've just finished investigating one, last week, and literally I'd start with the complaining witness.
Mm-hmm.
And talk to that person. Real importantly, when you do that, though, is you have to set it up that, first of all, explaining that participating in this investigation, you are protected against retaliation. And retaliation is actually a separate actionable offense. So, it could turn out that the claim of sexual harassment is unfounded, but then maybe a witness or the complaining party is discriminated against because they made the claim,
Right.
that in and of itself could create its own
Is that
claim.
protected by federal law?
Yes, federal law. Retaliation.
So-
You can't retaliate against anybody who, in good faith, brings a claim of any type of discrimination or participates in an investigation of any type of discrimination. The key is they have to participate in good faith. Doesn't mean they have to be accurate. It has to be actionable. It just, they can't decide, well, we're going to get together, three of us, and we're going to gang up on Tom here and file a charge against him.
Okay.
That's totally unfounded. But if, I think, you touched me or told me a couple of bad jokes in a wrong way, and I bring a claim and we decided, well, it really didn't arise to the level of actionable harassment, you're protected in that you can't be, retaliated against. But we may find that there's no real cause or claim of discrimination.
Like this thing I just heard on the radio about a politician kissed the back of the head of somebody. Joe Biden kissed the back of the head of somebody. Is that an actionable claim? Because I was I don't think it's normal.
Yeah.
I think it's a little weird, but
okay. So you got to, in the context it happened, no, because there's no employer-employee relationship.
Okay. So she wasn't a staffer.
Correct. No,
she was a campaign.
He was campaigning for one woman. Another was Ash Carter's wife while he was being sworn in as Secretary of Defense.
Okay.
So there was no employment relationship.
Gotcha.
Other thing to remember in the 1099 issue, a 1099 contractor has no claim of discrimination.
Interesting.
Under any.
Yeah.
So that's frequently another place we see that,
where they're found out.
Well, the contractor will bring a claim of discrimination. The immediate defense is there's no employment relationship. So now we're arguing over in that forum whether or not there's an employer-employee relationship.
So Phil, what is your at least your top best anecdotal employment story for the last 10 years? What's the most hilarious but anecdotally instructive employment story? Putting you a little bit on the spot, but I want to hear, you would like to hear something funny.
I'll take this a little bit
and you can
into the adult context.
Change the name to protect
Can we go adult context here? Okay.
Yeah, and use code names.
Okay, no names, never any names. So I represented
Bill, John,
a company that had a general sales manager that used to walk around it was like a cubicle area where people were making sales calls. Mm-hmm. And he had about a, foot-long sex toy that he used to walk around in his hand, slapping in his hand like this as he was talking to his female employee. And he also, they claimed so I get this charge of discrimination. He said he walked around with...
How is that discriminating?
Well,
sexual
harassment.
Okay, harassment.
Which is a charge of discrimination.
Yeah, I don't think it's good.
Yeah.
Don't get me wrong.
And so he's, the charge of discrimination says that he's walking around with a 14-inch dildo in his hand, banging it into his hand as he's talking to people, and that he shows naked pictures of himself and his girlfriend in a hot tub to his employees. And I read this and I'm thinking, okay, if there's ever a charge that is not made in good faith, this is crazy.
Yeah, can't happen.
Can't happen. I mean, this is
why would anyone
this
do
is
this
19 this is like 1998. I mean, this is not like 1950.
Why would anybody show pictures of themselves?
Correct. So I bring them in, and
I've heard that before.
What'd you say?
I said to their employees. Like,
yes, exactly. Yeah. So I start my investigation to respond to this charge of discrimination, and I've got the employee and I've got the owner of the company, and I say to him, Joe, actually is his real name, why would these people make these crazy allegations about you? And his response is, well, it's all true, but I never asked any of them out on a date.
Did you ever get to see the dildo?
No.
No.
So I kind of.
So what did you do when he said it's all true?
Well, I got him out of the room and I talked to the owner of the company. I said, you got to fire this guy. And you've got to go back and we've got to respond to this. That we had no idea this was going on. We have a policy that prohibits sexual harassment. It's got a complaint mechanism in that policy. The aggrieved party never availed themselves of the complaint mechanism. When we came to our attention through the charge, we investigated, we took prompt action, we fired this guy. The owner of the company says, we can't fire this guy. I've never had a sales manager this good.
What did the dildo make him better? I don't know. I'm just saying.
Maybe that was what kind of made people make phone calls.
Yeah, got them working.
It got their attention.
I would be terrified. I'd be like, no, God.
So my next response was, well, how much do you pay this guy a year? And the owner of the company said he was like $105,000 a year. I said, well, I think that's going to be our opening offer to resolve this claim.
Yeah.
And
did they let him go?
No, they never let him go.
Wow.
We re-educated him.
Did they add into their employee handbook no 14-inch dildos?
Well, we had a
12 inches
long
or less?
discussion. He was one of these guys that didn't recognize that there's different forms of sexual harassment. He thought the only kind of sexual harassment that existed
Asking somebody on a date
is, yes.
Or actually
is the
taking a proactive...
the quid pro quo.
Right.
You do this for me and I'll do something
Get
for
a promotion.
you. Right, exactly.
Okay.
I'm totally unfamiliar with a hostile work environment situation. Right. So we did a lot of education.
Wow. So you likened that a little bit to the kiss on the back of the head thing, where it was like, it was harassment, but it wasn't like I'm doing something for you to get something.
Right. So on the hostile environment, okay, so that the definition is something like creates a hostile, intimidating work environment on the basis of a protected classification. So it could be, a hostile racial environment. You've got nooses hanging around a workplace.
That would be bad.
Which we've seen.
Yeah. You've seen that?
It's been in the news in the last couple of weeks. There've been a couple of them.
Where? What state? What? In the U.S.?
Yeah. Oh, yeah. It's still.
I'm continually shocked by human beings.
Yes, indeed. But it comes down to it has to be pervasive and unwelcome conduct. So a simple bad joke or off-color joke of a sexual nature, whatever, is
not pervasive.
Not pervasive.
Michael
Correct.
Scott on The Office, pervasive?
Maybe. Okay, but but if we take the Sports Illustrated swimsuit calendar and we start hanging photos all over the office, it becomes more pervasive. I kind of say that, inappropriate statements, you need to
What if they're in the, so just I'm actually really curious. What if the Sports Illustrated swimsuit calendar is in your office, I don't have this, but in your internal office, just for you, you're not putting it around other people's offices, but people come into your office.
That's a problem.
That's pervasive.
Sure.
I mean, I see why. It's tasteless.
Yeah,
certainly. But it's an employment problem as well.
It's an employment problem. If you keep the swimsuit calendar in your desk and you only take it out of your desk drawer when you're alone in your office and you're going like this with the pictures,
because that's
okay.
Discriminating women, right? That would be a gender thing.
Yeah.
Now, what about just? And
I had a claim with you remember the Miss Rigid Tool Girl calendar? Rigid tools?
I know what rigid tools are.
Okay, so
you
got the woman with a pipe wrench that's about this tall across her body, standing in a way that she's wearing nothing but covered up with a pipe wrench.
And you had that in your office?
Not in my office. I had a client that had that problem.
In your client.
And interestingly, it was a mechanic shop, and nobody really cared until they got their first female mechanic.
Oh. And then she mentioned it.
Mm-hmm.
So, question about that: if I have a photograph or a picture in my office of, I think I do, of two guys shooting guns from my old military unit in a deployed zone, and somebody's against the idea of violence, and that's in my office. Is that discriminating against?
No, there's no protected class.
So you have to have a protected class at base, and you have to say, if I have in my office now, what if a homosexual person has a rainbow flag in their office, they're the protected class, but it offends a non-homosexual person. Is there the reverse?
There can be.
First
of all, in Virginia, sexual orientation isn't protected at the state level.
Because it's not protected federally. Sexual orientation, correct?
No, it's only,
it's protected state by state?
It's protected, I think, by executive order of government contractors.
Okay. But outside of that realm, in the private commercial space?
No, in D.C., sexual orientation on the state level is protected.
Right. D.C., California, New York, Maryland.
Yeah, not Virginia.
Not Virginia.
Virginia passed an executive order. I think Terry McAuliffe passed it, and somebody knocked it out.
So in Virginia, it's
before McAuliffe. I think Bob McDonnell knocked it out.
Okay.
Right.
So what would your advice be? What are the top 3 things today, takeaways for employers that you have 1 minute with an employer and you have to say, here are the top 3 things you need to know as an employer?
Top 3 things, I would say, get an offer letter, get a good offer letter.
Okay.
Actually, one thing we didn't talk about, make sure with your employees you fill out and complete I-9s or go through the E-Verify process.
Okay.
That is a real hot topic right now.
Isn't that mandatory?
It is mandatory.
But people don't do it.
You'd be amazed at how many people don't do it.
Okay.
You'd be amazed, government contractors are required to do it. I think if they've got a contract over $5,000, you'd be amazed at how many government contractors, small ones, don't do it.
Really?
Yeah. After that, get an employment manual and have somebody review it.
Okay. So due diligence, I-9s, offer letters, and an employment manual. Those are the three things that will protect you on the front end.
And another thing I do before hiring somebody, Google his or her name.
Yeah.
See what you find
that
out.
seems like Google seems like a shockingly good tool.
Yeah. I mean,
for that.
They call it the Google for a reason.
Yeah.
I taught a class in a high school a couple of years ago, and it was the greatest question I've ever received from anybody I've ever taught to. Was a kid asked me, what's the newest thing in employment law? And I thought for a second, and I pulled out my phone. I said, this is it. And they said, why? So because everything that goes on right now is memorialized.
Yeah.
Whether you've done something good or bad. And, one of these kids started, well, that's illegal. And I said, no, it's not. You're putting this in the public domain. And, if it comes down to, I've got two employees or two candidates, I'm trying to figure out who I want to hire.
And they're both the same.
Right.
Apples.
They both have almost identical experience, educational background. They're great. And then I start Googling them, and on one of them, all I see is pictures of them throwing up in trash cans. And the other one I see working with big brothers and big sisters and the rescue puppies. Who am I going to hire?
Yeah.
The drunk, obviously.
Yeah, because they're a lot more fun.
Exactly.
Yeah, the other person's boring.
No, but it's amazing what you'll find out about people.
Yeah, right.
You might find out that they've got some political views that maybe you don't want associated with.
Right.
Finding out, look at this. This person loves to march around, on Saturdays.
In white pajamas.
Exactly.
Right. Awkward. Right?
Yeah.
So,
you just might want to find out about those things. So I think Google is a really important thing.
Reordering then, Google the person first.
Google first.
Then send them a good offer letter and do their I-9 and have a good employment manual on the back end.
Yep.
So those are our big takeaways for today. David, do you have anything for the good of the cause?
No, that was really helpful.
Phil, I've been educated, actually, terrifyingly. Good thing is I don't run the employment at where we work, so that's good. But it's good to know this stuff for sure. Thank you for sharing this with our listeners, and hopefully you'll share this with your clients as well. Thank you for joining us on the Blackletter podcast. That's all for today's episode of Blackletter. Thanks again for listening. Join us next time when we talk about more Blackletter issues in creative ways. Make sure you subscribe to the podcast on iTunes and Google Play so you never miss an episode. And to catch us on video, check out our website at blackletterstudios.com.